So there is a lot to discuss, and there is very little time, so I will keep myself brief, and I will immediately hand over to our speaker, Maria Crippa, who we all know because she fantastically assisted in organizing this event. Maria is a PhD student in legal studies here in Milan at the Department of Cesare Beccaria, and works in the field of international criminal law, and her research is specifically focuses on the domestic implementation of international criminal justice. So she is truly an expert on this topic. Maria, the floor is yours.
Thank you, Julia. First, I would like to thank Professor Meloni and Professor Jesberger for this opportunity, and also my fellow panelists for the ideas we exchanged in the last weeks. My presentation will be, I hope you see it, and will be dedicated in the first part to crimes against humanity, starting from the fact that, as we already said many times during the last day, Italy doesn't have any provision really implementing crimes against humanity into the criminal law system. And also this late introduction of crimes against humanity would be a great opportunity for the legislator to implement some recent developments of international criminal justice, and not staying at the common law level set by the Rome Statute. The second part will be dedicated to the crime of genocide in light of the provisions already in place since 1967. And also bearing in mind that these provisions may be amended according to recent developments against of international criminal justice. I will dedicate just a few comments in the end to the crime of ecocide, highly debated and recently debated both at the national and international level, with the perspective of understanding the feasibility, but also the opportunity of introducing such crime into domestic legislation of international crimes in the Italian law. Crimes against humanity are not foreseen in the Italian criminal law system, and at the same time, as recalled yesterday also by Professor Fofani, many underlying crimes can be prosecuted as ordinary offenses. Ordinary offenses, of course, lacks the definition of the macro dimension of crimes in the contextual element, the so-called chapeau, and the violation of international goods belonging to the international community. In this sense, what was really well done by Progetto Cariplo in its Article 7 was the use of the element of state organizational policy to commit an attack only as the aggravating circumstance and not as constitutive element. This was a choice also made by many national legislations, and reflects also the ICTY and also ICTR statutes that didn't include the policy element as constitutive element. As we all know, the Rome Statute then used it, but the ICC jurisprudence, and I'm referring here to the Bemba trial chamber decision and also Katanga trial chamber's decision, enhanced this policy element only as a method to prove the widespread and systematic attack, and didn't require the formal adoption of this policy element. And for this reason, I think a potential legislation on international crime should adopt this perspective. Secondly, ordinary crimes, and this has also been said many times yesterday, are not always suitable to reflect international crimes, and in particular crimes against humanity. We have many examples in our criminal law of ordinary crimes that have a different definition, have a different scope or character rather than the underlying crimes of crimes against humanity. One example is the crime of enslavement. Another one is the illegal arrest, which is for us a reato proprio, meaning that require particular quality to be in place, while in the Rome Statute is considered a common crime. I will focus regarding international crimes definitions and crimes against humanity on the crime of torture, just to give you some hints, because we know that there will be another intervention later this day by an Italian judge, specifically on the jurisprudence on torture by the domestic tribunals. The crime of torture has been introduced only in 2017, And one of the main problems that were highly debated by scholars, but also in the perspective of judicial application, was the character of common offense. The second paragraph, and of course it is applicable only between private agents. In the second paragraph, the provision provides higher penalties for conducts by state agents violating or abusing their powers. In this sense, of course, the definition of torture as autonomous crime is problematic, but from an international perspective, in order to comply with international obligations to punish and prevent state torture, but also in terms of systematical and structural criteria of the same criminal law system. And in this sense, also, the definition of torture in the criminal law lacks the perspective of the superior responsibility for the lack of intervention in preventing or punishing and reporting crimes of torture. At the current state, crimes against humanity are only prosecutable as ordinary offenses. This means, of course, one of the biggest consequences that have been discussed yesterday and recalled also by Professor Jesberger, the non-compliance with the spirit of the Rome Statute. Has been recalled that the Rome Statute doesn't set direct obligations to implement its substantive provisions, but at least the indirect enforcement of international criminal justice requires that all states do their part to implement crimes against humanity. And secondly, the Italian judiciary, and especially the Italian authorities of the Appellate Court of Rome, which is competent for the cooperation with the ICC, may not execute requests of cooperation with the ICC. Italian procedural law of 2012 was the only piece of legislation that was introduced in Italian law system, especially on international crimes and related to the Rome Statute. It only provides procedural norms to cooperate with the ICC. And in this sense, the principle of double jeopardy was not included in the provision of this procedural law because, of course, the Italian legislation lacks the substantive definition of international crimes. But potentially, Italian authorities may not be able to assist in the cooperation with the ICC as long as they do not have any corresponding offense to apply in their domestic legal order. And most importantly, statutes of limitation may give to these crimes, may render these crimes not punishable when they expire. In this sense, the possibility for ordinary crimes to be subjected to statutes of limitation, even if they have the character of crimes against humanity, is of course contrary to the ICC statute, even if it's not a direct obligation, but Article 29 of the ICC statute, and also to the ILC draft convention, if it were to be finally adopted and implemented. In this sense, Article 6 of this draft convention requires national legislation to implement crimes against humanity in the Italian legal order, into their legal order. At the same time, it sets the obligation to avoid the running of statutes of limitation. And in this sense, it is clear the decision by the drafters of this convention to avoid the wording that was used in the 5th article of the Genocide Convention that led many states to consider their domestic legal order in compliance with the Genocide Convention, even if they only provided for ordinary offenses, for example, killings and bodily harms. The Italian judiciary also had to face the practical consequences of having statutes of limitations on ordinary offenses that are potentially crimes against humanity. And this was done in 2 cases. One is Plain Condor case, it was already mentioned yesterday, which had some problem about in the running of statutes of limitation. And the other one in the Reverberi case of 2014 for the extradition of potential perpetrators of crimes against humanity. I know that other discussants will cover this topic later, so I will limit myself here and maybe we can come back on this in the debate. prosecution of crimes against humanity into the national legal systems proved to be difficult, both in regard to technical skills that are required to judicial authorities, prosecutors and judges, but also in light of the need to demonstrate elements that are not common for ordinary judges, such as the contextual element or different modes of liability. In this sense, we have and we heard something about that yesterday in regard to Germany. We have the German example with some lessons learned and standpoint that can help the Italian legislation also in this sense from the procedural perspectives. But the Italian judges had also to already prosecute ordinary crimes as crimes against humanity as ordinary offenses. And this is particularly interesting in the cases of migrants coming to the Sicilian coasts. What I find really interesting here is that both the German Syrian cases and the Italian cases against migrants were, of course, favored by the presence of migrants on the territory. Of course, Germany and Italy have different jurisdictional criteria, but for the Italian judges to judge cases of violences against migrants, there was required the presence of potential perpetrators on the territory. And in these two cases, and also this will be covered later by other discussants, the Italian judges had to, in fact, prosecute violences against migrants in the Libyan camps as ordinary offenses. And I will also simulate the debate on these for the outcomes of these two different legal orders on the different prosecution of crimes against humanity. As such, crimes against humanity need domestication into the Italian legal system. And this is stretched between the international obligations that we already discussed yesterday and the constitutional principle. On the one side, the international obligations, and I'm referring here also to other international treaties, and maybe we can also discuss about it later on, also have to confront with the ILC draft convention. In this sense, this convention has to be taken as a common minimum denominator and set the minimum standard of prosecution of crimes against humanity. But of course, and in this sense, I think it would be interesting to exchange views on what are the non-negotiable provisions that are required in order to prosecute crimes against humanity and bar the impunity against these crimes. I will limit myself here only to some considerations on the strict legality principle that has been so many times recalled during these days under Article 25 of the Constitution. Of course, having to comply with this strict legality principle, the adoption of provisions on crimes against humanity may lead to a narrower and yet more substantiated notion of crimes against humanity than the Article 7 of the ICC statute. And this was, for example, also the solution of the Völkerstrafgesetzbuch in avoiding some clauses or some potential expressions that may be in violation of the legality principle. For the Italian legal order, one of the main problems may arise from the residual clause under letter K of Article 7, where it is foreseen the possibility to consider crimes against humanity other inhuman acts. And in this sense, of course, the use of this expression would be contrary to the legal certainty of an potential Italian norm on crimes against humanity. However, at the same time, the need for this clause may also let us to reflect on this part and to try to give better clarity to this provision, adopting both the specification of the elements of the crimes and the ICC jurisprudence, which consider it not only a catch-all clause to be applied without restriction, but also a category to be applied only to structurally similar crimes of same gravity and nature as the other crimes listed in Article 7, those complying with the eius dem generis constitutional jurisprudence. My last remarks on crimes against humanity regards the possibility to hold corporations liable for crimes against humanity. And it is, of course, something not foreseen by the Italian provision. And it was not also, as we all know, introduced in the Rome Statute, but many legal systems, we had some hints yesterday about that, provide the possibility to persecute corporations for crimes against humanity. In this sense, the French Court of Cassation Lafarge case that was cited yesterday is also very useful, as it gives us some indications on potential application also under the Italian law of 2001, setting the responsibility of legal entities for crimes against humanity. I will limit myself here because I'm running out of time by saying that the main outcome of this judgment would be relevant also for the Italian legislator, as long as it does not require the element of the pursuit of an economical activity to consider criminal corporations liable for participation and complicity in the commission of crimes against humanity. Whereas in our legal order, as we all know, this requirement is strictly considered by law 2031 of 2001. Another problematic point, apart of course the inclusion of crimes against humanity in the predicate crimes, that would be easier once the legislator adopted the Italian legislation on crimes against humanity, is also the possibility to attribute the knowledge to the managers of corporations. And also on this part, I think the Lafarge case can be helpful because the solution adopted by the Court of Cassation was not to consider corporations liable if if the managers had the knowledge of the intention to commit the attack, but they did not require the participation to the plan. And finally, incorporating crimes against humanity in the Italian criminal law system also give us some alternatives in the way of including them in the legislation. On the one side, we have the possibility of introducing one unified provision having both the contextual element and the single offenses. And the other one is introduction of subsidiary clauses in each of the offenses, ordinary offenses already in place. Of course, for all these the reasons that have been recalled yesterday, the idea of using one provision gives more clarity and renders the code more easily applicable also by the judiciary. And coming to genocide, Italian legislator already implemented genocide in 1967 with the almost literal adoption of Articles 2nd and 3rd of the Genocide Convention, transposing all the relevant conducts into the Italian law and also putting something else into the law, as was yesterday recalled by Antonio Cocco. There is also a provision on the imposition of signs and marks with a discriminatory significance. There are, however, at the same time, some limits also of this legislation of 1967. And this is, for example, in light of some inconsistencies. One of the major one is, of course, the non-exclusion of statutes of limitations with all the potential consequences that have already been recalled for crimes against humanity. In the second place, the introduction of an Italian criminal code of crimes against international law may also constitute the opportunity, as said, to broaden the notion of genocide in respect, for example, to the protected groups. Has been also already said yesterday by Professor Kroker, there is a difference between the implementation of international customary law and the exhaustion of customary law. In this sense, of course, the possibility to extend protected groups also to political, social, and cultural groups is affirmed not only by international jurisprudence, but also by many national legislations. Also because the shifting from the objective determination of criteria to demonstrate the notion of protected group to the subjective attribution by the majority has been assessed at the international level. Coming to the internal jurisprudence, the Rome Appellate Court already had to consider the political notion of protected groups in the judgment Acosta Jorge Eduardo of 2007, where the judges had to decide on the killings by Argentinian state officials of 3 Italians. And of course, this judgment was done on the basis of ordinary crimes, but at the same time, they put these killings into the context of a political genocide against opponents. So this is not a notion which is far away from the also the Italian jurisprudence. The common choice of other national legislation to use negative or residual clauses, such as for exclusion of in the absence of the main character belonging to the majority, has also to be verified in light of the legality principle. And here I just recall the consideration that I did before for crimes against humanity. Finally, and also maybe more for genocide than crimes against humanity, the introduction of these amendments needs to be balanced between the possibility of amending the law already in place and expanding the notion and its provisions, or introducing a unified code of international crimes, as it was done for the German legal order and Article 220A of the Strafgesetzbuch. And I think we also heard a comment on that yesterday. My very few comments will be on the crime of ecocide, as we already said, highly debated and also recently discussed in order of course, of the urgency that it brings, the need to hold especially corporations and states accountable for the commission of such crimes against the environment. And here, the problem of a very symbolic nature of this crime, which is of course well represented by the use of the name, which is very close to the crime of the crimes, is highly problematic. The two offenses are very different. I know there will be time also in the panel of sanctioning to come back to this notion. But from the perspective of legal certainty, the definition which was proposed by Philip Sands and the panel he chaired can constitute a problem also for the internal domestic legal order, as it is defined as an unlawful or wanton act. And of course, the lack of definition of these acts bring us the same problem we have been discussing these days on principle of legality. It seems to me that this crime is also protecting, of course, capital goods for the survival of humanity by indirect threats, and it is also focused on the future consequences of these acts, being closer to the recklessness model and also to the endangerment crimes. And therefore, I'm wondering if it would be advisable and also feasible introducing this crime into a domestication of international crimes. And also I hope to simulate the debate with other panelists on that, on the crime, on the nature of ecocide. And thank you for your attention.
Thank you very much, Maria, for your excellent and concise input and for raising so many interesting questions. We will now, without further ado, move on to the 5 discussants of this panel. And given the time situation, I would like to ask you to be within the 10-minute time limit. So the first commentator will be Dr. Marco Longobardo, who is a senior lecturer in international law at the University of Westminster in London, where he teaches public international law, international human rights law, and international criminal law, among other things. And he also authored an article which you can find in the background materials on the Italian legislature and the obligations to domestic criminalization. So Marco, please, the floor is yours.
Thank you, Julia, and it's my pleasure to be here, my duty to check the time. It's my pleasure to be here. I would like to thank Professor Meloni, Professor Jesberger, and Maria for this invitation and for the pleasure of being together in person talking about our research. So I am not a criminal lawyer as a matter of my background. I'm an international lawyer. And my interest in the topic of our conference today originated by a project that I co-led with my friend and colleague Francesca Capone of the Sant'Anna School of Advanced Legal Studies in Pisa. Our idea was that, our impression was that there is not enough attention on the obligations of domestic criminalizations that are imposed by international law, European Union law, in the sense that we don't pay much attention to the consequences of the lack of implementation of these obligations at the international level. So far today we have discussed what happens if there is no specific crime in the Italian legal system, how we can punish that person, what the victim can do. But we never stop asking ourselves, how is it possible that there is an international obligation that is not implemented with barely no consequence? So this was the idea behind our project that led to a special issue in the International Criminal Law Review. And this would be the main perspective from which I will discuss today, the problem of how Italy has implemented the duty to criminalize crimes against humanity and genocide. I would like to say that my reflection is largely based on obligations under some specific treaties, because as yesterday were Professor Jesberger, Antonio Cocco, today Maria said, the Rome Statute doesn't impose any obligation on domestic criminalization, except for one marginal obligation in relation to offenses against the justice. But we have some other conventions that are relevant: the Convention Against Genocide, the Convention Against Torture, the Convention Against Enforced Disappearances, the Convention Against Apartheid, even if Italy is not a party to that convention. All these instruments demand that member states adopt national legislation to criminalize certain acts. And a similar provision has been embodied in the draft convention on crimes against humanity prepared by the International Law Commission. So what I would like to reflect with you is that the fact that crimes against humanity and genocide are not completely criminalized, especially crimes against humanity, in the Italian legal system is not only a problem from the perspective of the respect of the principle of legality. That is just one side of the coin. But it's one side of the coin that is quite lenient towards the parliament. Our constitutional court told us that we cannot coerce the parliament to adopt criminal legislation. The court cannot intervene because there is the discretion about penalties, and so we can do very little. Or this is just one coin. On the other hand, under domestic and international law, the parliament has a duty to adopt that legislation. Or to be more precise, in front of Professor Pocard, that I feel I have to be specific, the Italian state has a duty before under international law, and the Italian parliament has a duty under national law in light of Article 117, paragraph 1 of the Italian Constitution. So I just would like to remind the audience that if we don't criminalize property crimes against humanity when we have a legal obligation to do so, this will have consequences at the international level. And sorry if I keep saying crimes against humanity, let's put together genocide and crimes against humanity. It's a very tedious discussion whether they are the same, separate. Phipps Sands wrote a masterpiece on that. It would be very boring if I try to talk about that. I mean, there could be responsibilities. There could be state responsibility under international law. And the main example was the crime of torture. We spent years saying, oh, we have to adopt a crime of torture at domestic level, but then, Italy was criticized by UN human rights committees for not doing this, but the committee presiding over the Convention Against Torture cannot bind the states. So Antonio Marchesi led a huge struggle, I don't know if he's today here, to try to give proper attention to this fact, but at the end of the day, Italy wasn't very much affected as a matter of state responsibility. Things changed under the system of the European Convention on Human Rights. And this is for me ironic because under the European Convention on Human Rights, we don't have an obligation of domestic criminalization. It's implicit. We have a strong court with binding powers that manage to read that obligation. And so we had to adopt a crime. Whereas Italy was neglecting the specific, clear, explicit obligation, the Convention Against Torture. But in any case, the lack of implementation of these crimes against humanity in the domestic legal orders of Italy, or the incorrect implementation of these obligations, can have repercussions on state responsibility. It's not a case that all these conventions have a compromissory clause that says that if there is any dispute about them, the International Court of Justice has jurisdiction over that dispute. It's not a chance the fact that all these conventions are not don't embody bilateral commitments, but they embody obligations affecting all the states in parties to that convention. This means that every state in that convention, every state party to the Convention Against Torture could bring potentially Italy before the International Court of Justice for incorrect implementation of these obligations. Clearly, you need to find political will to do so, but this is a possibility. And this is specifically a possibility if somebody gets away with his or her crimes against humanity against a foreigner, and then the state or nationality of that foreigner could have a very good case to say, as a state, I have an interest to bring the case before the International Court of Justice. So my only invitation is pay attention. Whereas under constitutional law in Italy, we could try to say, I think it's not correct, but we could try to say there is no way to coerce the parliament to adopt this legislation under Article 25. Okay. But nevertheless, Italy is in violation of its international obligation, and there is always the possibility of having another state with an interest or a specific injury in the case, to another state to bring a claim. And I think this fact that domestic criminalization of crimes against humanity, but also besides this field, is not just a manifestation of goodwill by states, but is the content of a specific obligation, should deserve more attention. With this, I finished my time. I thank you all for the attention. I give back the floor to our chair. Thank you.
Thank you very much, Marco, for this international law perspective. We now come to the second discussant who, I guess, will be zooming in from Berlin. Patrick Kroker, Dr. Patrick Kroker. Patrick is a lawyer at the European Center for Constitutional and Human Rights in Berlin. and he represents the civil parties in several cases involving international crimes in Germany, including the Al-Khatib trial in Koblenz, so the trial concerning crimes committed by the Syrian regime, and the importance of this trial was also emphasized by Wolfgang Kalek yesterday. So Patrick, the floor is yours.
Yes, hello. Warm welcome to everyone also from my side, from Berlin, and thank you very much for the invitation and for organizing, especially to you, Florian, Chantal, and Maria. As was said in the introduction, I will speak from a very practical background on several cases that are ongoing in Germany that we are involved in. Mainly, and these have been mentioned already in the introduction several times, and I imagine also yesterday quite a lot, cases concerning Syria. There's also the Lafarge case that we have been involved in very heavily, that was mentioned by Maria as well. So yeah, maybe I'll get to that as well in 10 minutes. If not, maybe we can come back to that afterwards. As has been mentioned also by Professor Zimmermann, and I'm sure also as has been a topic of discussion yesterday in the panel, the exercise of international criminal law in Germany and especially when it comes to prosecutions under universal jurisdiction is very much dominated by a focus on non-political cases. A problem, as I would see it, that we have generally, we also have a very clear focus with the German federal prosecutors on these cases. I will not speak about that. I will go more into the details from inside these trials, or one trial especially, as has been mentioned. There is a very large kind of standing out trial, I would say, against a former head of a Syrian torture prison, the prison being called Al-Khatib branch, which is why also the case referred to very often as Al-Khatib case. And it's a very large case of crimes against humanity, and the first case of crimes against humanity against a former member of the Syrian government. We have had several smaller cases before, but they were also almost exclusively war crimes cases. And so I think this hopefully will give some insight for panelists and discussants in this context as well. The case itself, as I said, rather large. There are 4,000 cases of torture, 68 killings, and lately also 2 cases of sexual coercion indicted as crimes against humanity. Possibly some cases of enforced disappearance will still be added. We had yesterday the 93rd trial day, actually the reason why I couldn't come to Milan. And the trial is approaching its end clearly. So I think it's possible to give some I don't know, first experiences, so to say, looking back. Concerning the contextual element that also you, Maria, have mentioned, we can say that it has been really part, I would say, of the evidentiary program, so to say, the evidentiary hearings of this case, to about 1/3 of the witnesses that almost spoke exclusively about the contextual element. Overall, I would say that it was at least half of the evidence presented that would be relevant for the contextual element, because also obviously people that speak about their specific crime that the accused is responsible for, it also is relevant to give the court a picture of the overall context and the legal elements of crime. However, I mean, there is a specificity, I would say, to this case that differentiates it from many other international crimes cases. I personally don't think that this evidence really is what is problematic here. I think there are not many legal problems attached to it because there is so much evidence available. And I'm speaking about, on the one hand, the quantity, on the other hand, also the quality of the evidence. Not only, I mean, very often we have a lot of crime-based evidence, and then we kind of need to build a pattern up from that, so to say. In this case, we have also a lot of insider witnesses, the so-called Caesar photos that show thousands of dead bodies of people that were tortured to death, very detailed accounts of mass graves, and so on and so forth. The legal problems that we had, and I want to speak about those in a bit more detail, were mainly referring to specific acts or crimes, as we have seen, and that partly also refer to the German legislation, notably to the constitutional standards of precision or legality, so to say, in Germany. And this concerns mainly the crime of enforced disappearance, that has been regulated for the first time in the ICC statute, but that regulation, the codification in the Rome statute, wasn't deemed to be precise enough by the German legislature according to German standards, and so it was basically split up into alternative modes of this crime, and more importantly, there was an element, or there were several elements added to it, and mainly the element. And this is now section 7, paragraph 1, number 7, for those who want to have a look now or later of the Code of Crimes Against International Law, that there is the requirement of the proof of an inquiry into the fate or the whereabouts of the detained / disappeared individual. And so this is, not going into the, I guess, even constitutional law discussion, if this is a necessity under German law, just from the, from the background of a human rights lawyer or an international criminal lawyer dealing with many survivors, etc., of these crimes, it's very difficult to have such an element satisfied in a climate of fear in which this crime is very regularly being committed, at least if it is being interpreted in the sense that there needs to be an official inquiry, because normally in these kind of settings, and this is true for Syria, this is also true for, I don't know, the 1990s in Turkey and dozens of other situations worldwide, an official inquiry would make it very likely for the person to be disappeared, him or herself. We still don't have a decision on that by the court, but this is where we see maybe in very interesting development of the specific requirements of crimes against humanity in Germany. Second, there was a big shortcoming in our view on this case, that crimes of sexualized violence that were very frequent and systematic in all Syrian torture prisons and still are, but also in the torture prison that is subject of this trial, they had not been indicted as crime against humanity, but as singular acts, so to say. However, I wouldn't link that to a specific weakness, so to say, of the German code. I mean, the German code is also, I mean, there is necessity to reform, definitely, but here in this case, in this very case, it was more due to insufficient investigations into these crimes that we see in all international criminal investigation. And the fact that this could be added now to the trial or to the indictments was also because there was new evidence that came to light. So this is not only, I would say, due to a specific difficulty in investigating international crimes. Maria said it, of course, all the professionals dealing with these kind of crimes coming from a national law background, they need to adapt. Overall, and concluding, I think it can be said that there is quite an emerging jurisprudence in national law on crimes against humanity in Germany, with an estimated 4 or 5 cases that are ongoing or that have been over very recently. And really contrary to what some people had feared when the first cases really started to happen about 10 years ago on crimes against humanity, we can say that the complexity of these cases or despite the complexity of these cases, it is still possible to adjudicate them in national justice systems. Of course, with I guess a lot of practical experience that needs to be there, that I'm sure was also subject of discussions yesterday. However, and as a last remark, so to say, another major shortcoming, which is really again zooming out of the law and of the trial, is something that is really to be kept in mind, that is to be able to effectively communicate about cases. So really speaking about the very reason that international criminal law is about to serve. In these cases, especially when we speak about universal jurisdiction, this concerns also the population that is concerned. In my example here today, Syria, and there need to be adaptations made as well, so that also the judicial authorities can effectively communicate to that community, and that is not at all the case in Germany. I will end here, and yeah, looking forward to further discussing maybe some issues later on. Thank you.
Thank you very much, Patrick, for this for these insights of a practitioner. We now move on to our third discussant, Dr. Giulia Mentasti. Giulia completed her PhD in criminal law here at the University of Milan at the Department Cesare Beccaria. And in her research, she focuses on issues related to the criminalization of migration. So it's yours.
Thank you. Good morning, everyone, and thank you for organizing this event and, of course, for inviting me here. In the minutes I have at my disposal, I would like to focus on a topic related to our panel issues and somehow with the speech that we just heard from Patrick Kroker. I refer, as our input said, to the consequences of prosecuting potential international crime as ordinary offenses in front of national courts. Much has already been said about crimes against humanity and what ICC statute provides and what Italian legislation should provide. There are many and complex issues that gravitate around this point, and these days of in-depth analysis and debate are a unique opportunity to explore a topic that is not always on the foreground. What I would like to investigate here are the violences perpetrated in Libya in the detention camps for migrants. In particular, I will talk about an important criminal case held in Italy, which involved the conduct of a Somali citizen in Libya against numerous migrants held in one of the many detention centers located on the coast. I choose this example, although unfortunately it's not the only one, because it was a very important case and the first to be held before an Italian court. In fact, Matamut case revealed the shocking conditions of detention of migrants trying to reach Europe from North Africa and the abuses perpetrated on them by the smugglers they paid to reach by boat the Italian coast. Before examining this important case and the possible different outcomes that this trial would have had if the crimes against humanity were present in the Italian Penal Code, I need to make some brief premises. First of all, it's worth remembering that according to Article 10 of the Italian Criminal Code, Italian court's jurisdiction for offenses perpetrated abroad by a foreign citizen against foreign citizens is found on a dual requirement. First, the presence in Italy of the wrongdoer, and second, the request to prosecute by the Minister of Justice. The second premise is that in my speech, I will only focus on the criminal liability of agents acting in the Libyan centers. Nevertheless, I cannot fail to mention that Libya's governmental authorities are under preliminary investigation by the ICC because of the violence committed against migrants held in Libyan detention centers. Not only, many scholars and also a project of a legal clinic from the Paris University investigate the possible liability of Italian and European authorities for complicity in the crimes against humanity perpetrated by the legal Coast Guard and by the other Libyan authorities in charge of the detention centers. This, of course, generates many and complex questions relating how to prove the actual cooperation by Italian authorities with the Libyan ones, the awareness on the part of our authorities of the crimes committed in the detention centers, and of course, the element of mens rea. But let's go back to Matamut case. Osman Mahmoud was a 24-year-old Somali citizen that was arrested after being recognized by fellow Somalis in a migrant reception center in Milan. Once collected the complaint and fulfilled the request to the Minister of Justice, investigation started, and later the prosecutor charged Mahmoud for kidnapping for the purpose of extortion, murder, sexual violence, and facilitation of irregular migration. All facts were committed in Libya between January 2015 and August 2016, the month in which the accused reached Italy by boat, together with other Somali citizens. From the intersection of the deposition of the 17 offended person, many dramatic and concordant details emerged and allowed the judges to reconstruct the context in which Mahmoud operated. For instance, all the migrants involved in this fact autonomously left Somalia, and once in Libya, they met an organization that transferred them to the collection camps where they would found Mahmoud. None of the migrants was informed in advance about the price of the trip, which was communicated only once they arrived at Bani Walid camp, a place in the Libyan desert, 100 kilometers far from Tripoli and Misurata, where Mahmoud asked them for the sum of $7,000 to be paid. Then the families of the migrants were contacted, and during the telephone calls, they heard their loved ones being beaten under the threat of death if the sums were not paid in time. Only when the request of the amount was paid, migrants were transferred to the coast in order to start their journey by sea to Italy on boats, overloaded with people in conditions that exposed them to serious dangers to safety. The migrants were detained in a huge hangar capable of holding up to 500 people, surrounded by a courtyard guarded by armed people. In the camp, the migrants were unable to move, to talk to each other, and the only other buildings present were the guardians' rooms and the so-called torture room. All the witnesses indicated Mahmoud as one of the men in charge of the camp, and all agreed that the violence personally perpetrated by Mahmoud took place against anyone at any time of the day and often for no apparent reason. It was enough that someone had violated the rule of silence for Mahmoud to beat him with sticks, plastic pipes, and bars, breaking limbs, and in some cases, causing death. Some of the detainees had also been taken to the torture room, where, away from the eyes of others, Mahmoud beat them for hours and burned their wet bodies with electricity or loose plastic. As for the women, their destiny was marked by the sexual violence that the accused inflicted on them almost daily, taking them to his room, tying their hands behind their backs, and abusing their bodies. Many of the people subjected to the violence died in the following days in the total absence of medical care, and the other inmates were entrusted with the task of burying their bodies, but not before leaving them exposed as a warning for a few days. The only way to put an end to this torture and save one's life was to pay the money, a real price for freedom. Due to these facts now exposed, the first instance judge sentenced Mahmoud to the harsh sentence of life imprisonment with a daytime solitary confinement for 3 years. The decision, in the absence of other evidence produced in the trial, was only based on the evaluation of the testimonies of the victims that were considered reliable and enough to establish beyond any reasonable doubt that Mahmoud was culpable. Mahmoud changed the sentence, but in March 2019, the life sentence was confirmed. The crimes for which Mahmoud was convicted were common offenses present in the Italian criminal code. They were kidnapping of 500 people for extortion purposes, pursuant to Article 630 of our criminal code, aggravated by the death of 13 of the kidnapped, and for having acted for abject and futile reasons. Then the other crimes were sexual violence, pursuant to Article 609 of Criminal Code, aggravated also because they were often committed against young girls. Then the last was the facilitation of illegal immigration, pursuant to our law on immigration. Before going on to examine the relationship within the common crimes charged on Mahmoud and crimes against humanity, I would like to point out that the case of Mahmoud is not isolated. In recent years, in fact, Other Italian courts have been called to judge other prison guardians operating in Libya and arrived in Italy by boat together with other migrants. I just mentioned, for example, the Condé case, where the Tribunal of Messina in Sicily sentenced 3 people, 1 Guinean and 2 Egyptian, to 20 years of imprisonment, later reduced to 12 in the second degrees, for kidnap, criminal association, and torture committed in Libya in the Waya migrant detention camp. In this camp, as in Bani Walid, migrants were daily subjected to electric shocks, sexual violence, lack of medical assistance, and deprivation of water and food. Still, the Criminal Court of Agrigento has sentenced it to 10 years in jail for the crime of conspiracy and reduction into slavery, a person held liable for terrible acts of violence against a group of migrants waiting to leave for Italy. The frame that emerges from these trials is consistent with the tragic tales of victims of Matamut case, thereby confirming the systematic character of the atrocities the migrants detained in the several concentration camps of Libya are subject to. Most of the crimes committed by Matamut can be found among the conducts provided for in Article 7 of the ACC status. I refer in particular to murder, imprisonment, torture, and rape. As we all know, the differences lies in the contextual element that requires to verify that the individual conducts were committed as a part of a broader, systematic, and a conscious attack direct against the civilian population. I think that this element will not be so difficult to prove. In more than 130 pages of sentence, the Court of Milan has given us a picture of violence and abuse that goes beyond the sole personal responsibility of Matamut. And in my opinion, it would have been suitable to integrate the element of context that distinguishes common offenses from crime against humanity. So what could be the advantages deriving from the introduction of crimes against humanity in the Italian Penal Code? I think we could exclude, at least for these crimes, any reasoning in terms of more severe penalties, given that the Italian Penal Code already sanctions with very heavy penalties the conduct that is in this case would have potentially fell within the crimes against humanity. In my opinion, the possibility to use crimes against humanity instead of normal offenses would allow the facts to be given their real name. Matamut was not a serial killer or a rapist. As demonstrated in the sentence, he committed those crimes as a part of a widespread context of violence against migrants, exploiting their position of weakness and in the total compliance of political system and of the militias and organization that often, with the financing of European countries, manage the departures of migrants in the Mediterranean. Last, and I conclude, recognizes that in Libya, not just murders, violence, and sexual abuses are committed, but that these conducts are crimes against humanity, could have a wider repercussion on the policy of externalization of border control between Libyan authorities and the European countries, and in the management of SAR operation in the Mediterranean seas. Thank you.
Thank you very much, Julia, for presenting us this interesting case. We will now move on to Dr. Luigi Prosperi. Luigi holds a PhD in International Legal Order and Human Rights from Sapienza University of Rome, and he has worked in various capacities at several international criminal tribunals. And as of last month, very recently, he joined the University of Amsterdam as a lecturer in international criminal law. So congratulations, Luigi, and the floor is yours.
Thank you, Julia. First of all, I will be super brief, just thanking the organizers for inviting me for this amazing conference and for hosting us in this wonderful venue. Really, I'm so happy to be here in Milan. It's the first in-person conference after 2 years, so I'm really thrilled. And I want to thank all the other speakers in this panel because I think they already touched upon all the issues I'm going to delve into. So I'm also not going to double down on the overarching issues of the obligation to criminalize. In my presentation, I'd like to focus instead on the legal implications of the decision not to incorporate crimes against humanity in the Italian legal system, and in particular from the perspective of the principle of legality. Because this decision, and this is something I really want to stress, has had a very concrete and regrettable impact. So in particular, the lack of a specific criminal provision sometimes has de facto resulted in impunity. This is precisely what happens when the conduct a suspect has been charged with has been qualified as an ordinary crime, in relation to which the statute of limitations has already expired. And I'm not talking about an hypothetical scenario, but a very realistic one. And I will mention two very recent cases that Maria already mentioned. The first one is the Plan Condor case, because on the 17th of January 2017, the Corte d'Assise of Rome ruled that the statute of limitations had expired in relation to no less than 18 defendants whose conducts could not be characterized as enforced disappearance, but only as kidnapping and bodily injury. That, as you can easily understand, it's not exactly the same conduct. And most of all, these are offenses in relation to which the statute of limitations normally expires, and correct me if I'm wrong, in 6 and 10 years respectively. And the conducts were committed between 1975 to 1989. So they were expired like for some years. On the same grounds, meaning the expiration of the statute of limitations, on the 17th of July 2014, the Corte di Cassazione had confirmed a decision of the Court of Appeals of Bologna denying the extradition to Argentina of Franco Reverberi, an Italian-Argentinian Catholic priest that was allegedly involved in tortures committed in Argentina during the dictatorship against political opponents. So in that case, the conducts had been committed between 1976 and 1983. And again, these conducts were characterized as bodily injury by the Italian judges. So when criminal provisions don't properly capture what we could call the, the full wrongfulness of a conduct, this is something that also the speaker that preceded me was stressing. When they don't capture the full wrongfulness of a conduct, one of the effects is that the provisions don't attach a proportional punishment to the conduct, and therefore they come with a rather short statute of limitations. This is a lesson that Italy doesn't seem to have learned, because again, in 2017, when the Italian legislator finally decided to adopt a law in order to incorporate a crime of torture into the domestic legal order and the domestic criminal code, the penalties attached to the crime amounted to a maximum of 10 to 12 years. Moreover, during the debate, the parliament decided not to grant an exception to the rule concerning the statute of limitations, because there was also this additional option. And as a result, the statute of limitations for the crime of torture currently expires in 10 to 12 years. So what is the lesson to learn from this experience, in my opinion? So the problem is that irrespective of whether an obligation to criminalize arises from international treaties Italy has ratified, there is another reason why the Italian legislator should incorporate criminal provisions on international crimes, and in particular on crimes against humanity, into the domestic legal system. This is really the only way not to risk transforming Italy into a safe haven. Yesterday, we spoke about the no safe haven principle in Germany. Well, we should really follow the example. In addition, when incorporating crimes against humanity specifically, I think Italy should also introduce a provision establishing that no statute of limitations apply in relation to any of such crimes. Because you can have penalties attached to the underlying crime, to one of the underlying crimes, that may be proportional, but may be not long sentences. So in that case, you really need the exception to the rules on the statute of limitations. And this would be also in line with Article 1 of the Convention on the Non-Applicability of Statutory Limitations, which was adopted in 1968, but which to this day, Italy has not signed. So this is also another issue. Conversely, in case Italy decided not to do that, I think that one could also infer that Italy's determination to fight against impunity, which was also enshrined in the Rome Statute, has to be intended maybe just as a symbolic pledge, maybe empty words. And I come to my second and final point, and it's still about the principle of legality. This principle is also at the heart of a point I'd like to make regarding the definition of a crime of ecocide. As you know, last June, an independent expert panel, which I will call IEP, chaired by Philip Sands and Dior Folso, unveiled the definition of ecocide, which should be incorporated in an Article 8 ter of the ICC statute. So ecocide will thus become the 5th international crime falling under the jurisdiction of the ICC. Well, in 2021, the IEP defined ecocide as the unlawful or wanton acts committed with knowledge that there is a substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. I'd like to focus on the drafting technique. This is something we heard from Antonio Coco yesterday, because the panel opted for a very specific drafting technique, which comes with an issue, I think, with a problem. So they decided not to provide a material description of the actus reus. And interestingly enough, when Philip Sands, one of the chairs, was asked about this decision, he explained that the other option, that is the introduction of a list of criminal acts, was discarded because the panel feared that it may have given the impression that the acts which would not be included in this list were not important, were not prosecutable as a result. So what is the problem with this? I think in this specific regard, I would like to agree with something that has been published, and sorry for my pronunciation, on Folkerecht's blog, I think, by a blogger, that was saying that actually there is a problem with this open clause, with not providing the list of potential crimes, of acts, the actus reus list. Because of course, there is also a principle of legality enshrined in the Rome Statute at Article 22, paragraph 2. And a corollary of the principle of legality is the specificity of the actus reus. So there may be a problem, but since I see that we are also running out of time, I will stop here. I am very much looking forward to the debate after the panel, and also to hear from somebody maybe about the legal implications of a definition of ecocide, also the other legal implications. Thank you so much.
Thank you very much, Luigi. I would also like to add that there is also an article you wrote in the background materials where you expand on your arguments. So let's move on to the panel's finals discussant, Hugo Relva. Hugo is a legal advisor for Amnesty International and leads the organization's work on the draft convention on prevention and punishment of crimes against humanity. And I was told that he's zooming in from Argentina, so it's very, very early in the morning, I guess. Hugo, the floor is yours.
Thank you, Madam Chair. I know I'm postponing your lunch in Europe, but my breakfast is also has been put off for a few minutes. First of all, I would like to express my gratitude to the Università di Milano and the Humboldt University for the kind invitation to express Amnesty International view on this important topic. First of all, I was thinking on something that was said by Maria minutes ago about this important distinction between ordinary offenses and crimes under international law, crimes against humanity. And she mentioned correctly several, distinctive elements. I would like to also mention two, which are from our perspective very important. The first one is the question of immunities ratione materiae. As you probably know, the International Law Commission is drafting guidelines on immunities of state officials from foreign criminal jurisdiction. And in Article 6, the draft Article 6 provides that foreign state officials are immune abroad for ordinary crimes, are immune. And Article 7 provides for some exceptions to this rule, including genocide, war crimes, crimes against humanity, etc. So as Professor Longobardo said, it's not just a theoretical question, it's something that will be in practice in the future. And a second distinctive element between ordinary offenses and crime under international law is this question of scope of jurisdiction. Ordinary offenses are normally in most countries subject to territorial jurisdiction, while crimes under international law should be subject to universal jurisdiction and other extraterritorial bases. So this is a brief comment on what was said minutes ago. I would like to share with you briefly some of the main recommendations that my organization makes to all states while implementing the Rome Statute and other treaties under national law. Amnesty International thinks that the national legislation of states should provide that the crimes in the Rome Statute and other crimes under international law are crimes under national law. And in our view, the definitions should be as broad as the definitions in the statute. But whenever international treaties, like, for example, Protocol 1 to the Geneva Conventions or customary international law contains a broader definition than those in the statute, these definitions, the broader one, should be incorporated into national law. And let me put two examples. If you read the definition of the crimes against humanity of enforced disappearance in the Rome Statute in Article 7, it contains the last, at the end of the expression, a very unfortunate addition, which is, in our view, a jurisdictional threshold, which is that the enforced disappearance should have been committed with the intention of removing the person concerned from the protection of the law for a prolonged period of time. In our view, this is, as I said, a jurisdictional threshold for the purposes of restricting or limiting the competence of the ICC and should not be reproduced by national legislation because there is no need whatsoever of any need of restricting the competence of national courts. And the same with regard to the crimes against humanity of persecution, which at the end of the definition contains an addition in connection with any act referred to in this paragraph or any crime within the jurisdiction of the court. That is to say that the prosecutor of the ICC will never be able to accuse somebody of committing just persecution. Should be persecution plus another crime. And we are of the view, we explained that question in a thick paper years ago, that this expression, the jurisdictional threshold for the ICC, should be abrogated while implementing the Rome Statute into national law. This is something that the Italian authorities could bear in mind at the time of implementing the treaty. We also think that there are three other crimes under international law that all states should implement under national law: the crime of torture, the crime of enforced disappearance, and extrajudicial execution. And when I said enforced disappearance, I'm making reference to enforced disappearances committed by state agents or group of persons who act with the acquiescence of the tolerance of state agents, and also, as provided in Article 3 of the Convention, by non-state agents. Could be, for example, an armed opposition group or insurgents. As I said before, we also recommend all states to provide for universal jurisdiction and other extraterritorial jurisdictional bases with regard to all crimes under international law. As you probably know, all states are permitted to exercise universal jurisdiction with regard to crimes under international law and also to ordinary offenses, but the states are also encouraged by my organization to provide for the audedere judicare obligation, which is the obligation to extradite or prosecute. We are also of the view that principles of criminal responsibility in national legislation for crimes under international law should be consistent with customary international law. If you read Article 28b of the Rome Statute about the responsibility of civilian superiors, is not as strict as, for example, the definition contained in Protocol 1. And we are of the view that this other wording should be chosen by states. And by the way, if you also read Article 6.3 of the draft articles on prevention and punishment of crimes against humanity adopted by the ILC in 2019 and now before the consideration of states at the 6th Committee of the General Assembly, has amended the wrong definition in Article 28b of the Rome Statute, and now military and civilian superiors are they apply the same standard of responsibility. We also think that this question has been, I'm sorry, my cat is visiting me. We also have the question of statutory limitations that has been mentioned before. We encourage all states to promptly adhere or accede to the 1968 Convention on the Non-Applicability of Statutory Limitations to War Crimes and Crimes Against Humanity. And likewise, this is the view of my organizations, as statutory limitations do not apply to genocide, crimes against humanity, and war crimes, they should not apply to civil or criminal proceedings in which victims of any crime under international law, including crimes against humanity, seek full reparation. We are of the view that civil claims should not be subject to statutory limitations. We also think that there is a rule today under customary international law, which is the non-applicability of amnesty, pardons, and other measures of impunity. All states should provide for the non-applicability of impunity for crimes under international law. This view has been shared by the ICTY, the Inter-American Court, the European Tribunal, the African Commission, the Special Court for Sierra Leone, and a number of national courts. Another recommendation that my organization makes to all states is that trials must be fair and exclude always the death penalty. Unfortunately, we have a number of cases, mainly in Africa, where the laws implementing the Rome Statute under national law include the death penalty. We think that crimes under international law, including genocide, crimes against humanity, and war crimes, should be tried always by ordinary civilian courts to the exclusion of any military jurisdiction, a military court, a military commission, etc. Amnesty International considers that the jurisdiction of military courts over criminal cases should be limited to trials of military personnel only for breaches of military discipline. We also think that the states should recognize the right to consular assistance for all foreigners or stateless persons deprived of his or her liberty. We also think that national legislation should provide for the definition of victim that could be inspired, for example, in Article 24 of the Convention on Enforced Disappearance, or perhaps a better definition is the Rule 85 of the Rules of Procedure and Evidence of the ICC. My last suggestion that I would like to share with you now briefly is that Amnesty International is of the view that national legislation should provide that no rule whatsoever under national law shall prejudice the trial and punishment of any person for any act or omission which at the time when it was committed was criminal according to the general principles of law recognized by the community of nations. This is reflected in Article 15.2 of the ICCPR, to which, by the way, Italy and Germany are states parties too. There is a wonderful decision by the Special Tribunal for Lebanon, Judge Cassese presiding, I think it was 20 11, in which the court, the appeals chamber, explained the true meaning of the legality principle. For reasons of brevity, I will conclude now. Thank you very much for your attention.
Thank you very much, Hugo, for your comments and for getting up early for us. Do we have a few minutes for discussion? So maybe I would like to collect a few questions first, if there are any, and then.
Alice Riccardi, Roma 3. So first of all, thank you very much for this very exciting panel. I actually have like thousands of questions, but I will try to keep it as short as possible. So my first question will go to Maria. I have a question concerning the reference that you made to the principle of double jeopardy and the possibility that you mentioned that Italian judge may refuse surrender in case of individuals with an arrest reached by an arrest warrant on crimes against humanity, concerning the fact that we don't have criminal provision on this. Now, if I got you correctly, this stance is based on a horizontal understanding of cooperation regimes regulating arrest and surrender, like in extradition cases, right? However, well, to me, the ICC cooperation regime actually very much departs from horizontal classical extradition model, and cooperation obligations that stem from the statute as also confirmed actually by the drafting history of the statute itself, entail that states may refuse surrender on very exceptional basis and very limited basis, and this does not include double jeopardy. Therefore, I'm curious to know what would be your opinion, what in your opinion actually would be the legal basis, also taking into consideration article, don't remember whether it's article 12 or 13 of the cooperation law of 2012, what would be the legal basis for an Italian judge in such a scenario to refuse extradition, well, not extradition, but surrender based on double jeopardy, and the reasoning of the judge. And if you think that to avoid such risk, it would be necessary to write down the positive law on cooperation, that double jeopardy is not applicable in the relationship between ICC and its states parties. The second question instead goes to Marco. And I, of course, very much as an international lawyer liked the international lawyer touch on state responsibility. And I was rereading actually the draft articles of the International Law Commission that were just quoted by the last speaker on crimes against humanity in the latest version, and also the comments inside the International Law Commission. And well, none of the outcome of the draft of the works on the draft is not that clear, in the sense that there is a common obligation, a general obligation to criminalize crimes against humanity, as I understood is your position. And therefore, it would be amazing to know what is your opinion on whether there is an obligation stemming from customary law generally imposing states to criminalize crimes against humanity. Thank you.
Thank you. There was another question by Professor van der Welt.
I try to keep it brief because we can discuss it over lunch, but I would be interested to know whether, to know your opinion of Maria and Ms. Mentasti and of Luigi in particular, whether it is likely that the state will ever prosecute its own perpetrators of crimes against humanity. Very briefly about this, because This is, of course, the article by David Luban, Borders of Crime Against Humanity, Politics Gone Cancerous. So the state forsakes its prime responsibility to prosecute people. Yes, they were very much unwilling or unable. So I am fully in line with the proposition of Mr. Prosperi, who argues you must implement it because you must give a later government, after this bad, evil government has been toppled, give the opportunity to prosecute them. And therefore you have to, of course, you have to abolish all kinds of statute of limitations.
Thank you. Any other brief questions, remarks? Online maybe? No? Okay, then I would suggest we just, Luigi, starting with you, and then okay.
Well, with regard to Professor van der Wiel's question, well, yeah, of course, I agree. I mean, would be adding insult to injury in the case after a dictator was toppled or an authoritarian regime was toppled, to also have the judges notice that there is a statute of limitations that expired because maybe 20 more years have elapsed. So no, of course I agree. And it's not only that, but I think there is another reason why it's super important to have domestic provisions. So I can give you an example. At one point in 2010, 2011, there was a debate in the Italian, I think it was the Senate, anyways, in the Italian parliament, about the lack of specific provisions on crimes against humanity, because somebody actually raised the issue of, okay, what happens if Gaddafi gets to Italy somehow, and we are for instance, required by the ICC to transfer Gaddafi, and we don't have the criminal provisions, so there is actually no law to prosecute it under the Italian, to prosecute the crimes under the Italian legal system. And then there is a principle of legality actually barring the transfer, the extradition. And somebody replied that there was still customary law, which I think was a very problematic answer, but that was it. So there was no discussion whatsoever, and this was not taken as an opportunity to go ahead. They had a project at the time, but they just decided to kill the project as to the substantive part. But I think this is an example. It's very important. There are neighboring countries where people may flee, you know, and in that case, it's super important that also the neighboring country has the criminal provisions and at least can extradite or transfer under the ICC statute the suspect.
Thank you very much, Alicia, for the question that gives me the opportunity to add 2 more sentences. And I don't see why you are skeptical, in the sense that these obligations of domestic criminalizations exist for specific treaties, and clearly the Convention Against Torture is only concerned with torture, the Convention Against Apartheid is only concerned with apartheid. A general obligation is spelled in Article 6 of the draft Convention on Crimes Against Humanity, that says each state shall take the necessary measures to ensure that crimes against humanity constitute offenses under its criminal law. After you asked the question while Luigi was replied, I went to reading very quickly the commenter saying, oh my God, I missed something big, but I cannot see that I missed it. So assuming that this convention is adopted, or assuming that this convention reflects current customary international law, I think that the obligation exists. I just would like to add the 2 sentences on the fact that there is a trend in considering these obligations like very generous with the state's discretional power. This is a mistake under international law. These are not obligations of conduct that require states to just behave in a diligent way towards an aim. But these are obligations of result, and this was said clearly by the International Court of Justice in the Belgium versus Senegal case, in relation to the duty to criminalize torture under the Convention Against Torture. So for sure, we could allow some technical time to states to adopt that legislation, and we could discuss the length of that time. I don't think there is any clue, but it's an obligational result. So there is no other way to implement it other than adopting the legislation. And I think this exhausts my answer. And if I missed something, Alicia, we will discuss this over lunch. Thanks.
Yeah, I just give a short answer to the last question that was made. I think that is very difficult for a state to prosecute its own perpetrators, and for Italy is the same situation. But the lack of the presence of crimes against humanity in our legal order makes it more difficult to prosecute, because of course, when the crimes against humanity are by their nature of sort of macro crimes, and so when it's charged to a single, you don't have to charge the single episodes, but also the overall situation. So the absence of this kind of crimes well, makes it more difficult for judges to charge the, let's say, the Prime Minister or the Minister of Interiors of the single fact, for example, sexual violence or a murder, even a contribution in the murder. So the presence of different crimes that creates crimes against humanity maybe could make the work of judge easier, even always very difficult. Thank you.
Thank you. Before I give the floor to Maria, I just want to briefly ask Patrick and Hugo if they have any comments or any last remarks briefly.
No, it's been really interesting to follow the discussions from far away on the Italian context, yeah, I can second a lot of what Hugo has said, that it, from the point of the protection of human rights, also as one of the sources, so to say, that feed international criminal law, not to make the mistake of falling behind international standards, as has been done in Germany several times. On the other hand, in the Italian context, as Professor Zimmermann has mentioned this morning, you would have not the problem of needing to compromise among many states parties. So I'm very, very happy to have been part of this briefly, and looking forward to hearing what will happen in Italy next. Thanks.
Thank you, Patrick. Hugo, do you want to add a sentence? He's gone. Hugo, can you hear us? No. Do you see him? Okay, so otherwise, maybe you just...
Okay, thank you for your questions. I will start with Alice.
No, thanks. Your lunch. Thanks.
Thank you. No, unlike the extradition system, as you said, there is no possibility for the double jeopardy to constitute an obstacle in the cooperation between Italian authorities and the ICC. And that is the reason why I put it in brackets. What I found, so the only possibility would be the expiration of statutes of limitation, of course. The thing I found interesting in in reading the historical developments of the law on cooperation was that there was a provision on these double jeopardy, so the possibility to have both the international crime in the Rome statutes and also the ordinary crimes into the Italian law system. And then it was kept until the last reading before the Senate, and then of course it had to be left off because of the lack of a domestic implementation of international crimes. And secondly, to come to the question of Professor van der Wilt, I agree fully with my fellow discussants. The thing I would like also to highlight was the lack of unwillingness in the case of the discussion on Gaddafi, and also that maybe, and this is a difference between Italy and Germany in terms of what could be the crimes brought before national judges, the international crimes before national judges, Patrick at one point said that Germany, in his opinion, is only prosecuting non-political crimes. At the same time, the Italian crimes against migrants would be highly political, especially in light of what you suggested, and Julia also recalled about the responsibility of Italian authorities for crimes against migrants. For now, we of course have only cases of crimes committed in Libya by non-Italian perpetrators. And also here, I think there is both a problem about structures. As Julia said, these are only ordinary crimes subjected to immunities. And this is also something I thank Hugo Relva also for having highlighted. I didn't put jurisdiction and immunities in my presentation because of course we will discuss them tomorrow. But these are of course some of what I call the non-negotiable provisions that the Italian legislator has to keep in mind in implementing crimes against humanity. And so this is, of course, both unwillingness and the lack of a proper legislation on ordinary crimes and international crimes. And finally, just a last comment on what has been said during the panel. I think that the running of statutes of limitation is not only problematic in terms of sanctioning. It's not about giving a higher sentence for such crimes, because of course, crimes against humanity have also different offenses which could be less or more grave. And in this sense, it is inherent to what Hugo Relva said. It is a prohibition for crimes against humanity, especially. And I don't know if you have any more questions.
May I ask a question? Sorry. Or not?
Yes, please.
Julia, sorry.
Very brief.
Sorry, Alberto Di Mandina. I am behind the column. Sorry. Sorry. So my question is. Well, I'm convinced that Italy is unable to prosecute international crimes, but for maybe small exceptions. And I think we take for granted this. But my question is, given the actual legal order and certain ordinary crimes that can be used in order to prosecute some crimes that in concrete may be deemed to be international, don't you think, I'm speaking rather as an activist than as a criminal lawyer now, but don't you think that Article 8 of our criminal code could be used in order to prosecute international crimes without the problem of the presence of the person on the territory, because they are subjectively political crimes. And then you don't need this link in order to adjudicate crimes committed by foreigners against foreigners. Thank you.
Okay, was this addressed to one of the online speakers? Because otherwise we would keep this question for the discussion in the afternoon. Okay, so maybe we can keep this for the discussion in the afternoon, because I think we have to go to lunch. So this would conclude our panel. Thank you very much to all the speakers for the excellent presentations and comments.